former President Jacob Zuma has an 11th hour stay of execution. The Constitutional Court has agreed to hear his application to have the order against him rescinded. So on Tuesday, the Apex Court ordered Zuma to be imprisoned for 15 months for contempt of court. He had ignored its order to testify at the State Capture Commission of Inquiry. So joining me now is Lawson Naidoo from the Council for the Advancement of the South African Constitution to perhaps give us some clarity on the matter. Lawson, always a pleasure speaking to you. The Constitutional Court has agreed to hear former President Jacob Zuma's application for the rescission of its contempt of court ruling against him. Just how significant is this development?
Well, good evening, Faith. Yes, it is a significant development. This is uncharted legal territory in many respects, this application for a rescission order against an order of the Constitutional Court. But what would ordinarily happen is when an appeal is filed in a matter, that would stay the execution of the order that is being appealed. But as we know, it is not possible to appeal an order of the Constitutional Court, the highest court in the country. So this is not an appeal, and it therefore does not automatically suspend the court order that was handed down last Tuesday. This application for rescission should, in my view, have been accompanied by an application for an interdict to stay the execution of that order and to avoid Mr. Zuma having to go to jail as ordered by the court. It would appear to be another piece of poor legal advice that Mr. Zuma has received.
Yeah, you're saying that it's a poor legal advice, but it looks as though, as you're saying, that the Constitutional Court will hear former President Jacob Zuma out in July. Does that mean, though, that he has to hand himself over to the police come Sunday?
Well, the order of the Constitutional Court that was handed down on the 29th of June stands. It is a full force and effect. And the first part of that order was that Mr. Zuma should hand himself into a police station by tomorrow, Sunday. And if he fails to do that, the Minister of Police and the National Police Commissioner have been instructed by the courts to take appropriate measures to deliver him to a correctional facility. That should happen anyway. If he is detained by the time of the 12th, then he would have a right to appear in court on the 12th, but as we know from the directions of the court, that matter is going to be heard virtually. So wherever Mr. Zuma is, he will be able to participate in those proceedings virtually on the 12th of July.
Jacob Zuma has also argued that his 15-month jail term for contempt is a possible death sentence, and he also insists that at the very least the Constitutional Court should allow him the opportunity to argue that it will be lessened. Does that pose a possibility of a complete dismissal or even a possibility of reviewing the judgment as it stands? You've articulated clearly that what is said by the Constitutional Court and what is handed down, it stays. But will that then warrant him a dismissal of already what has been happening at the Constitutional Court? Or will they just simply say, listen, what we judge, we stay by our judgment, and you just simply have to accept it?
Well, in his application to the Constitutional Court yesterday, Mr. Zuma seeks to lay various bases for why the court should rescind the order that they made last week. It's a fairly convoluted and confused in places a set of arguments that is being put forward. In relation to the sentence and the length of the sentence, Mr. Zuma had an opportunity when the court asked him shortly after the hearing in March to make submissions on affidavit as to what an appropriate sanction should be. Mr. Zuma simply ignored the court at that point and filed instead a 25-page letter full of vitriol and animosity towards the court. The court has now agreed to hear the matter, and they will no doubt hear the arguments that his legal team puts forward. But many of the arguments that Mr. Zuma is now raising have already been dealt with by the court in a very, very comprehensive judgment by both the majority and minority judgments delivered on Tuesday. There's clearly been robust debate amongst the justices of the Constitutional Court who heard this matter, who have weighed up the pros and cons of the various arguments that he is now belatedly seeking to make, and they've made a very considered judgment. So I would be really surprised if the court is convinced by Mr. Zuma's legal team that they got it so very wrong.
And as you're saying, Lawson, that we're in uncharted territory here. This has never happened. So in light of the fact that this has never happened, what are the possibilities and even the possible impact of an overturn of the Constitutional Court judgment? Should the Constitutional Court, after hearing what has been presented by former President Jacob Zuma, decide, actually, we made a mistake here, what impact could that have on the Constitutional Court itself?
Well, these are court processes, and, courts sometimes get things wrong. Things are overturned on appeal on a regular basis, whether from the High Court to the SCA or sometimes from the Supreme Court of Appeal to the Constitutional Court. Judges are fallible like anybody else. But as I say, given that this was such a well-considered judgment, there were two comprehensive judgments, both the majority judgment and the minority one, which it's important to note that both those judgments found that Mr. Zuma was guilty of contempt of court. They only differed on the sanction to be imposed. So there's clearly been a detailed engagement with the issues that Mr. Zuma now seeks to raise. So I would be very surprised that the court would be convinced by any new arguments that he might make that they got the law so horrendously wrong.
Lawson Naidoo, will leave it there for this evening from the Council of the Advancement of the South African Constitution. Well,